Ever wonder what really stops a government from doing whatever it wants? Well, there's a simple phrase we hear all the time: the rule of law. It sounds simple, but this one idea is pretty much the bedrock of modern society. And today, we're going to break down what it really means and ask whether it's maybe starting to crack. So, let's start with the big one, right? Is anyone ever truly above the law? I mean, the answer to this question is what separates a stable democracy from a dictatorship. It's the difference between a world where a speeding ticket applies to everyone and one where the powerful can just ignore the rules the rest of us have to follow.
And look, this is not some newfangled idea. It goes back thousands of years, all the way to ancient Greece. You can see right here, Aristotle saw it as the ultimate defense against tyranny. The idea is simple, but it's so powerful. The law has to rule over everyone, even the people in charge of the laws themselves.
Okay, so let's get into a clear definition. When we talk about public law, which is really all about how government power is used and controlled, the rule of law isn't just a side note, it's the absolute foundation. It's the core principle that's supposed to guarantee fairness and make sure everyone is accountable. This definition from Lord Bingham is, well, it's pretty much perfect. The key thing to get here is just how wide it is. It's not just about the government being bound by law, it's about everyone. Every person, every company, every authority. And notice the details, because they matter. Laws have to be public, they can't be used to punish you for something you did in the past, and disputes have to be settled by independent courts. Each one of those is a crucial shield against the abuse of power.
But, like any big idea, there are different ways of looking at it. And legal thinkers have generally split into two major camps. It all boils down to a debate between the how and the why of the law.
So, on one side you have the formal view. This is all about the how. Are the laws clear? Are they made public? Is there a judge who can apply them fairly? This view doesn't really ask if the law itself is a good law. But then, the substantive view says, whoa, hang on, that's not enough. It argues that for the rule of law to mean anything, the laws themselves have to have a moral core. They have to protect basic human rights and actually deliver justice. Building on all this, Lord Bingham created what's basically a practical checklist for a healthy democracy. And you can see right there at number 4, protect human rights. He plants his flag firmly in that substantive camp. But I want you to pay special attention to number 5, access to justice. This is so important because a right you can't afford to defend in court isn't really a right at all. We're going to come back to that point later, for sure. So, okay, that's the theory. But how does this all work in the real world? How do you actually stop a government from crossing the line? Well, this is where the courts come in. They are meant to be the guardians of the rule of law. And this idea was cemented centuries ago in this huge landmark case. We're going all the way back to 1765. The king's messengers just broke into a guy's home, claiming they had government authority. But the court's ruling was historic. It said government officials need clear legal authority to do something like that. They can't just do what they want. It established right then and there that the state itself has to follow the law. But this principle is always tested, especially in a crisis. During World War II, the government passed a rule allowing it to lock someone up without trial, just because the Home Secretary had reasonable cause to believe they were a threat. This set the stage for a massive courtroom showdown. So in this case, Liversidge versus Anderson, most of the judges just deferred to the government. They basically said, well, if the Home Secretary thinks it's reasonable, we can't question it. But one judge, Lord Atkin, stood completely alone, and his dissent was this fiery defense of the rule of law. He accused his fellow judges of being more eager to give power to the government than the government itself. He argued that reasonable cause has to be based on facts a court can actually look at. And here's the incredible part. Decades later, the courts openly admitted that the majority got it wrong, and Lord Atkin had been right all along. It was a massive moment. It affirmed that the whole point of the judiciary is to scrutinize power, especially when the stakes are at their highest. Okay, so if the law applies to everyone, are there any exceptions at all? Well, yeah, there are, but they're very specific and very narrow. And these aren't about putting certain people above the law. They're practical things to help the state function. For example, parliamentary privilege means politicians can have open debates without worrying about getting sued for what they say. So these are carefully defined exceptions to a really powerful general rule. So that brings us right up to today, because these principles we've been talking about are facing all kinds of new and complicated challenges. creating some pretty serious tension in legal systems all around the world. A perfect and pretty controversial example of this is the UK's Rwanda policy. In 2023, the highest court in the land, the Supreme Court, looked at all the evidence and ruled that, as a matter of fact, Rwanda was not a safe country to send asylum seekers to. Why? Because there was a real risk they could be sent back to face harm. So, what happened next? Well, in response, Parliament passed a new law. But this law didn't change the facts on the ground in Rwanda. Instead, it simply declared, by law, that Rwanda is safe. And this created a direct clash. You have a judicial ruling based on facts on one side and a parliamentary declaration on the other. It's a huge tension between the power of Parliament and the role of the courts. And that brings us to another threat, one that's a bit more practical. You see, the rule of law promises everyone access to justice. But what happens when that access is basically blocked because you can't afford it? This chart tells a pretty stark story. Just look at the real-world impact of cuts to legal aid. You see this dramatic spike in people who are forced to represent themselves in court. And when you have an ordinary person with no legal training trying to argue against a professional lawyer, the scales of justice, well, they're not exactly balanced, are they? This doesn't just bog the system down. It creates a real danger that cases are decided not on the facts, but on who can afford the better lawyer. And the challenges just keep coming. You've got these so-called Henry VIII powers that let ministers change laws without proper scrutiny. You have computer algorithms making massive decisions about people's lives. But how do you challenge a decision when you don't even know the logic behind it? And then there's the growing trend of politicians openly criticizing judges for their rulings, which over time can really chip away at the judicial independence the whole system relies on. Let's look at one final critical case that kind of ties all these themes together, the Belmarsh case. After the 9/11 attacks, the UK passed laws to detain foreign terror suspects indefinitely, without a trial. But, and this is the crucial part, these laws didn't apply to UK citizens who might be suspected of the exact same thing. And here's Lord Bingham again, just cutting straight to the heart of it. He said the problem was the discrimination. You just can't justify applying a law to one group of people, but not another simply because of their nationality. The law was struck down not because the threat wasn't real, but because the government's response violated that fundamental principle of equality. So, all of this leaves us with a really critical question for the future. We say the courts are the guardians of the rule of law. But in an age of artificial intelligence, powerful governments, and intense political pressure, who guards the guardians? Who makes sure they can still do their job? In the end, maybe we come back to this powerful statement by Lord Hope. It's a stark reminder that an independent court system enforcing the principle that no one is above the law isn't just a nice-to-have, it is the ultimate foundation of the entire constitutional system. It's what stands between a society of laws and a society of unchecked power.